Will Nancy J. Grant presiding.
Good morning.
Morning.
Morning, Judge.
Morning,
Your Honor, now calling the case of People of the State of Michigan versus Roy Larry, case number 2023-284-940-FC, and People of the State of Michigan versus Marco Visbiscus, case number 2023-284-941-FC.
Good morning, Your Honor. Josh Biscuit for the people.
Bring the argument.
Rick Polanco for the people.
And James Thomas for Mr. Visbicus.
Good morning, Your Honor. Michael Nunn for Mr. Visbicus.
And good morning, Mitchell Bibber for Roy Larry.
Ready for the jury?
Yes.
Yes, Your Honor.
All rise for the jury.
You may be seated. Good morning. Good morning. Members of the jury, the evidence and argument in the case are finished. I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If the lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendants are innocent. This presumption continues throughout the trial and entitles the defendants to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that they are guilty. Every crime is made of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendants are not required to prove their innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendants not guilty. A reasonable doubt is just that. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable, if you're careful, consider examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that Mr. Visbicus did not testify. It must not affect your verdict in any way. There is evidence that the defendant, Roy Larry, has been convicted of a crime in the past. You may consider this evidence only in deciding whether you believe the defendant is a truthful witness. You may not use it for any other purpose. A past conviction is not evidence that the defendant committed the alleged crime in this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that defendants are charged with crimes and are on trial is not evidence. Likewise, the fact that they are charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to any witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide the case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide the case based only on the evidence submitted during the trial. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influence that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People hear and see things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything the witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Roy Larry and Marco Bisbikis are both on trial in this case. The fact that they are on trial together is not evidence that they were associated with each other or that either one is guilty. You should consider each defendant separately. Each is entitled to have their case decided on the evidence of law that applies to them. The prosecution has introduced evidence of a statement that it claims the defendant Marco Bisbikis has made. Before you may consider such an out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find the defendant did make the statements, you may give the statements whatever weight you think they deserve. In deciding this, you should think about how and when the statements were made and about all the other evidence in the case. You may consider the statements in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence when we actually see or hear. So, for example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts also proved by indirect or circumstantial evidence. Circumstantial evidence or evidence that circumstantial evidence is evidence that normally reasonably leads to other facts. So, for example, if you see a person coming in from the outside wearing a raincoat covered small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. There has been some evidence that defendant Roy Larry tried to run away after the alleged crime. This evidence does not prove guilt. A person may run or hide for innocent reasons such as panic, mistake, or fear. However, a person may also run or hide because of a consciousness of guilt. You must decide whether the evidence is true, and if true, whether it shows the defendant had a guilty state of mind. You've heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether defendants had a reason to commit the alleged crimes, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove the defendants had a reason to commit the alleged crimes. He only has to show the defendants actually committed the crimes and that they meant to do so. You've heard evidence that was introduced to show that the defendant, Marco Bisbikis, committed crimes for which he is not on trial. If you believe this evidence, you must be very careful only to consider it for certain purposes. You may only think about whether this evidence tends to show that the defendant had a reason to commit the crimes, the context in which all the witnesses in this case knew each other, and the relationships that developed among them. You must not consider the evidence for any other purpose. For example, you must not decide that it shows the defendant is a bad person or that he is likely to commit crimes. You must not convict the defendant here because you think he is guilty of other bad conduct. All the evidence must convince you beyond a reasonable doubt that the defendant Bisbikis is committed the alleged crimes, or you must find him not guilty. Defendants are charged with conspiracy to commit murder. The prosecutor says that this crime took place in Oakland County. The prosecutor also says that the crime took place between on or about January 2022 and on or about August of 2022. The prosecutor does not have to prove that the crime was committed on those exact dates, but only that it was committed reasonably near those dates. Some of the testimony in this case might show that the defendant Bisbikis committed... Do you want me to say that again? It seems like double instruction. That's fine. Some of the testimony in this case might show that defendant Bisbikis committed other bad acts. Remember, the defendant is not on trial for any of those acts. You must find the defendant Bisbikis committed the alleged acts, so you must find the defendant Bisbikis not guilty. The alleged crime of conspiracy to commit murder in this case is made up of several acts. The prosecutor only has to prove that one of these acts took place in Oakland County. He does not have to prove that all of them took place there. The defendant's intent may be proved by what they said, what they did, how they did it, or by any other facts and circumstances and evidence. You've heard that one witness, Darnell Larry, has been convicted of crime in the past. You should judge this witness's testimony the same you judge the testimony of any other witness. You may consider his past criminal conviction along with all the other evidence when you decide whether you believe his testimony and how important you think it is. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendants are guilty. You've heard that a lawyer or lawyer's representative talked to one or more of the witnesses. There is nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. Angela Reptopoulos and Darnell Larry say they took part in the crimes the defendants are charged with committing. The evidence clearly shows that Angela Reptopoulos and Darnell Larry are guilty of the same crimes the defendants are charged with. Such a witness is called an accomplice. You should examine an accomplice's testimony closely and be very careful about accepting it. You may think about whether the accomplice's testimony is supported by other evidence, because then it may be more reliable. However, there is nothing wrong with the prosecutors using an accomplice as a witness. You may convict the defendants based only on an accomplice's testimony if you believe the testimony and it proves the defendant's guilt beyond a reasonable doubt. When you decide whether you believe an accomplice, consider the following. Was the accomplice's testimony falsely slanted to make the defendant seem guilty because of the accomplice's own interests, biases, or for some other reason? Has the accomplice been promised that he will not be prosecuted, or promised a lighter sentence, or allowed to plead guilty to a less serious charge? The evidence has shown that both Angela Reptopoulos and Darnell Larry have been allowed to plead guilty and to reduce charges with minimum sentences of 4 years and 6 years respectively, in exchange for their truthful testimony. If so, could this have influenced their testimony? Does the accomplice have a criminal record? In general, you should consider an accomplice's testimony more cautiously than you would that of an ordinary witness. You should be sure you have examined it closely before you base a conviction on it. You've heard testimony from several witnesses who have given you their opinions as experts in various fields, namely Dr. Bernardino Pacris in the field of forensic pathology, Professor Julie Bellion in the field of wills and trusts, Robert Charlton in the field of firearms and tool mark identification, Amanda Fazzi in the field of DNA analysis, and Special Agent Brian Tolsis in the field of historical cell site analysis. Experts are allowed to give their opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about all the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards that you use to evaluate the testimony of any other witness. You've heard testimony that witnesses Angela Reptopoulos and Darnell Larry each made an agreement with the prosecutor about charges against them in exchange for their testimony in this trial. You have also heard evidence that Angela Reptopoulos and Darnell Larry faced a possible penalty of life without the possibility of parole as a result of those charges. You are to consider this evidence only as it relates to Angela Reptopoulos and Darnell Larry's credibility, as it may tend to show Angela Reptopoulos and Darnell Larry's bias or self-interest. One of the issues in this case is the identification of defendant Roy Larry as one of the persons who committed the crimes. The prosecutor must prove beyond a reasonable doubt that the crimes were committed and that defendant Roy Larry was one of the persons who committed them. In deciding how dependable an identification is, think about such things as how good a chance the witness had to see the offender at the time, how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, whether the area is well lighted, and the witness's state of mind at the time. Also, think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict defendant Roy Larry, as long as you believe the testimony and you find that it proves beyond a reasonable doubt that the defendant was one of the persons who committed the crimes. And let me make it clear. If you think you might be missing something that I'm saying here, everything I'm reading, you're going to get the written copy of. So don't panic if you're someone who learns better by visual as opposed to hearing it. Okay. In this case, defendant Bisbicus is in count one with some of the grammar's a little off. In this case, defendant Marco Bisbicus is in count one with first-degree premeditated murder and count four with assault with intent to murder or intentionally assisting someone else in committing those crimes. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove these charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the alleged crime was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or during the crime, the defendant did something to assist in the commission of the crime. Third, at the time, the defendant must have intended the commission of the crime alleged or must have known the other person intended its commission, or that the crime alleged was a natural and probable consequence of the commission of the crime intended. In this case, defendant Marco Bisbikis is charged in counts 2 and 5 with committing the offense of possessing a firearm during the commission or attempted commission of a felony firearm, or intentionally assisting someone else in committing that offense. Anyone who intentionally assists someone else in committing a crime is as guilty as the person who directly commits it and can be convicted of that crime as an aider and abetter. To prove this charge as to Marco Bisbikis, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the crime of possessing a firearm during the commission of a felony or attempted commission of a felony was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, that before or while the crime of possessing a firearm was committing or attempted to commit a felony was being committed, the defendant did something to assist in carrying, using, or possessing the firearm. It is not enough that the defendant did something to assist in the commission of the underlying felony. By words, acts, or deeds, the defendant must have procured, counseled, aided, or abetted another person to carry, use, or possess a firearm during the commission or attempted commission of a felony. Third, at the time, the defendant must have intended that a firearm be carried, used, or possessed by another during the commission or attempted commission of a felony. It does not matter how much help, advice, or encouragement a defendant gave. However, you must decide whether the defendants intended to help another commit the crime and whether help, advice, or encouragement actually did help, advise, or encourage the crime. In count 1, the defendants are charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or someone he aided or abetted caused the death of Daniel Lee Hutchinson. That is, that Daniel Lee Hutchinson died as a result of multiple gunshot wounds. Second, that the defendant or someone whom he aided and abetted intended to kill Daniel Lee Hutchinson. Third, that this intent to kill is premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means the defendant or someone whom he aided and abetted considered the pros and cons of the killing, thought about and chose their actions before they did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of the case. The killing cannot be the result of a sudden impulse without thought or reflection. The 3.8 and 16.5 are the exact same instructions, so I'm not going to read 3.8. All right?
Yes, sir. Yes.
You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant or someone whom he aided and abetted caused the death of Daniel Lee Hutchinson, Jr. That is, that Daniel Lee Hutchinson, Jr. died as a result of multiple gunshot wounds. Second, that the defendant or someone whom he aided and abetted had one of these three states of mind. He intended to kill or intended to do great bodily harm to Daniel Lee Hutchinson, Jr., or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the result of their actions. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the types of wounds inflicted, the acts and words of the defendants, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results to follow from the use of a dangerous weapon. A gun is a dangerous weapon. Premeditation and deliberation may be inferred from any of the actions of the defendants which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there is premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. In count 2, the defendants are charged with the separate crime of possessing a firearm at the time they committed the crime of first-degree premeditated murder. To prove this charge as to Roy Dante Leary, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed or attempted to commit the crime of first-degree premeditated murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed or attempted to commit the crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. To prove this charge as to Michael Bezbikis, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the crime of possessing a firearm during the commission of a felony or attempted commission of a felony was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of that crime. Second, that before or while the crime of possessing a firearm when committing or attempted to commit a felony was being committed, the defendant did something to assist in carrying, using, possessing the firearm. It is not enough to find the defendant did something to assist in the commission of an underlying felony. By words, acts, or deeds, the defendant must have procured, counseled, aided, or abetted another person to carry, use, or possess a firearm during the commission or attempted commission of a felony. Third, at the time the defendant must have intended that a firearm be carried, used, or possessed by another person during the commission or attempted commission of a felony. In count 3, the defendants are charged with the crime of conspiracy to commit first-degree premeditated murder. Anyone who knowingly agrees with someone else to commit first-degree premeditated murder is guilty of conspiracy. To prove the defendant's guilt, the prosecutor must prove each of the following elements against each defendant beyond a reasonable doubt. First, the defendant and someone else knowingly agreed to commit first-degree premeditated murder. Second, the defendant specifically intended to commit that the defendant specifically intended to commit or help commit that crime. Third, that this agreement took place or continued during the period from January 2022 through August of 2022. I have already defined the crime of first-degree premeditated murder for you. An agreement is the coming together or meeting of the minds of two or more people, each person intending and expressing the same purpose. It is not necessary for the people involved to have made a formal agreement to commit the crime or to have written down how they are going to do it. In deciding whether there was an agreement to commit a crime, you should think about how the members of the alleged conspiracy acted and what they said, as well as the other evidence. To find the defendants guilty of conspiracy, you must be satisfied beyond a reasonable doubt that there was an agreement to commit first-degree premeditated murder. However, you may infer that there was an agreement from the circumstances, such as how the members of the alleged conspiracy acted. If there was a conspiracy, you must decide as to each defendant whether that defendant was a member of it. You may only consider what the defendant did and said during the time the conspiracy took place. A finding that the defendant was merely with other people who were members of a conspiracy is not enough by itself to prove that the defendant was also a member. In addition, the fact that a person didn't act that furthered the purpose of an alleged conspiracy is not enough by itself to prove that the person was a member of the conspiracy. It is not necessary for all of the members to know each other or know all the details of how the crime will be committed, but it must be shown beyond a reasonable doubt that the defendant agreed to commit the crime and intended to commit or help commit it. The defendant is not responsible for the acts of other members of the conspiracy unless those acts are part of the agreement or further the purposes of the agreement. If the defendant agreed to commit a completely different crime, then he is not guilty of conspiracy to commit first-degree premeditated murder. A person who joins a conspiracy after it has already been formed is only responsible for what they agreed to when joining, not for any agreement made by the conspiracy before they joined. You may consider evidence of what the other members of the alleged conspiracy did or said before the defendant became a member, but only in order to determine the nature and purpose of the conspiracy after the defendant joined. Members of a conspiracy are not responsible for what other members do or say after the conspiracy ends. Each defendant in this case is entitled to have his guilt or innocence decided individually. You must decide whether each defendant was a member of the alleged conspiracy as if they were being tried separately. To determine whether each defendant was a member of the alleged conspiracy, you must decide whether each individual defendant intentionally joined with anyone else to commit first-degree premeditated murder. In conspiracy cases, it is often difficult to decide each defendant's case on its own because of the amount of evidence that is admitted against the other defendant. If any evidence was limited to one defendant, you should not consider as it to the other defendant. It is not enough to find that there was criminal agreement to commit first-degree premeditated murder. Even if you do find that there was a conspiracy, you must still determine whether each defendant separately was a member of that conspiracy. The defendants are charged in count 4 with assault with intent to murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant or another whom he aided and abetted tried to physically injure another person. Second, that when the defendant or another whom he aided and abetted committed the assault, he had the ability to cause an injury, or at least believed that he had the ability. Third, the defendant or whom he aided and abetted intended to kill the person he assaulted. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. Some objects, such as guns or bombs, are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. If the defendant threatened to use an object or used an object in a way that was likely to cause serious physical injury or death, it was a dangerous weapon. You must decide from all the facts and circumstances where the evidence shows that the pistol in question here was a dangerous weapon. A gun or pistol is a firearm. A firearm includes any weapon which is designed to or may readily be converted to expel a projectile by action of an explosive. It does not matter whether or not the gun or pistol was capable of firing a projectile or whether it was loaded. In count 5, the defendants are also charged with a separate crime of possessing a firearm at the time they committed the crime of first-degree premeditated murder. To prove this charge is Does 5 go to 4 or does 5 go to 1?
5 goes to 4.
And 4 is assault with intent to commit murder. So that needs to be changed. In count 5, the defendants are charged with a separate crime of possessing a firearm that committed assault with intent to murder. In count 5, the defendants are also charged with a separate crime of possessing a firearm at the time they committed the crime of assault with intent to murder, which is count 4. And I wrote that down here so you understand which counts go with which counts. To prove this charge as to Roy Dante Leary, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant committed or attempted to commit the crime of assault with intent to murder, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, at the time the defendant committed or attempted to commit the crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. To prove this charge as to Marco Michael Bisbicus, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the crime of possessing a firearm during the commission of a felony or attempted commission of a felony was actually committed either by the defendant or someone else. It does not matter whether anyone else has been convicted of the crime. Second, that before or while the crime of possessing a firearm when attempted to commit a felony was being committed, the defendant did something to assist in carrying, using, or possessing the firearm. It is not enough that the defendant did something. It is not enough to find that the defendant did something to assist in the commission of the underlying felony by words, acts, or deeds. The defendant must have procured, counseled, aided, or abetted another person to carry, use, or possess a firearm during the commission or attempted commission of a felony. Third, at the time the defendant must have intended that a firearm be carried, used, or possessed by another during the commission or attempted commission of a felony. Possession does not necessarily mean ownership. Possession means that either the person has actual physical control of the thing as I do with the pen I'm now holding, or the person knows the location of the firearm and has reasonable access to it. Possession may be sold, where one person alone possesses the firearm. Possession may be joint, where two or more people share possession. As to counts 1, 2, 4, and 5, the prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about June 1, 2022 within Oakland County. As to count 3, the prosecutor must prove beyond a reasonable doubt that the crime occurred on or about January 2022 through on or about August of 2022 within Oakland County. When you go into the jury room, you'll be provided a written copy of these final instructions as I've just read them to you. You should first choose a foreperson. The foreperson procedure that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. I've already given you instructions regarding a lesser offense. As to any count which includes a lesser offense, you must first find the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offense. If you believe the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It is up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to the principal offense again after discussing lesser offense if you want to. And what I'm specifically talking about is count 1. First degree premeditated murder. That's the first thing you should be considering. And if you can't agree on it or you want, you can then consider second degree murder, and you can go back to first degree murder if you want to. All up to you. That's the only charge that has a lesser offense to it. If you have any questions about the jury instructions before you begin deliberations or have questions during deliberations, please submit them in writing and give them to the clerk. Possible penalties should not influence your decision. If you find the defendants guilty, it is the duty of the judge to fix the penalty within limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly to lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go into the jury room to deliberate, you may take your notes and will be given these full instructions. If you want to look at all the documents or exhibits that have been admitted, you just need to ask for them. When you go into the jury room, you will be given a written copy of the instructions you've heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. The defendants are charged with 5 counts, that is, with the crimes of first-degree premeditated murder, felony firearm, conspiracy to commit first-degree premeditated murder, assault with intent to murder, and felony firearm. These are separate crimes, and the prosecutor is charging that each defendant committed all of them. You must consider each crime separately in light of the evidence. You must return a separate verdict for each defendant. For each defendant, you may return a verdict of guilty of one or more of the alleged crimes, guilty of a less serious crime, or not guilty. Remember that you must consider each defendant separately. There are 2 verdict forms listing the possible verdicts. The first one is People of the State of Michigan versus Roy Dante Leary. That reads, there are 5 counts in this form. The form is 2 pages. You may return only 1 verdict for each count on this form. Mark only 1 box for each count. Count 1, first-degree premeditated murder. Mark only 1 of not guilty, guilty of first-degree premeditated murder, guilty of the lesser crime of second-degree murder. Count 2, possession of a firearm in the commission of a felony, felony firearm. Mark either not guilty or guilty of felony firearm. Count 3, conspiracy to commit first-degree premeditated murder. Mark either not guilty or guilty of conspiracy to commit first-degree premeditated murder. Count 4, assault with intent to commit murder. Mark either not guilty or guilty of assault with intent to commit murder. Count 5, felony firearm. Mark either not guilty or guilty of felony firearm. And there's a date line and a signature line for the foreperson. The second verdict form that you need to fill out reads, People of the State of Michigan versus Michael Vesbikas. There are 5 counts on this form. This form is 2 pages. You may only return one verdict for each count on the form. Mark only 1 box. So count 1, first-degree premeditated murder, not guilty, guilty of first-degree premeditated murder, or guilty of the lesser crime of second-degree murder. Count 2, possession of a firearm in the commission of a felony or felony firearm. Mark either not guilty or guilty of felony firearm. Count 3, conspiracy to commit first-degree premeditated murder. Mark either not guilty or guilty of conspiracy to commit first-degree premeditated murder. Count 4, assault with intent to commit murder. Mark either not guilty or guilty of assault to commit murder. Count 5, felony firearm. Mark either not guilty or guilty of firearm. Again, a date line and a signature line for the foreperson. Could you all approach? Twelve individuals may deliberate in a criminal matter, so 3 of you will be drawn off by lot now. And let me make it crystal clear. The 3 that are going to be alternates will be held in a separate room. So you're going to be here as long as the court member is deliberating. The 3 who are alternates, and obviously I don't know who those 3 are yet, you may not deliberate. You may not talk about the case because you are only alternates and you're not participating in the bulk of the deliberations. So when you all take a break, you'll be told this each time, nobody can be deliberating. The bulk, whoever the jurors are, cannot deliberate outside that jury room. So if you take a recess, and you go to lunch, or you have a break, don't deliberate during any recess. And again, the alternates cannot do any deliberations on their own.
Juror number 15.
Sir, Sir, if you could please step out of the box and be seated.
Number
Oh, I'm sorry. Number 15?
Yes. Which is juror in seat number 3.
No. We changed your seats number when we brought them all in.
Okay.
So, juror number 15. Thank you.
Juror number 5. And juror number 4.
All right. We lost. There's Sarah.
Do you swear or affirm that you will, to the best of your ability, keep the persons sworn as jurors on this trial in some private and convenient place? That you will not communicate with them orally or otherwise unless by the order of the court, and you will not, before they render their verdict, communicate to anyone the state of their deliberations or the verdict they have agreed upon?
I did. You are the juror that will decide this matter. You may go back into the room, choose your foreperson, and begin your deliberations.
All rise for the jury.
Okay, you may be seated. I asked counsel at the bench, I'll ask them again for the record, any objections to the way the instructions were read?
No, Your Honor.
No, Judge.
No.
Here, anything else for the record?
No, Your Honor.
I do have,
Forget the
you
exhibit.
have all the exhibits together, and you also have the defendant's exhibits, so they're all together.
I don't have theirs, so we've got ours.
Mr. Thomas, if you can make sure, or Mr. Naughton, if you can make sure all the exhibits together, so if they, in my practice, if they ask for even one exhibit, I send all the exhibits in.
We agree.
Okay, okay, thank you. Oh, you may be seated, thank you.
You can make that up. Sit down.
case of the people of the state of Michigan versus Roy Larry, case number 2023-284940-FC, and people of the state of Michigan versus Marco Despicas, case number 2023-284941-FC.
John Skrinsky for the people.
Brandon Barlick for the people. Rick Polanco for the people.
And Jim Thomas for Mr. Bisbicus.
Michael for Mr. Bisbicus.
Mitchell Revere for Roy Larry.
I have received a note from the jury. They reached a verdict this morning. May they have them brought in?
Yes.
Yes, Your Honor.
Yes.
Yes, Your
Before, if y'all can be seated for a second. You have all been you've all been very, very, very respectful during these proceedings, and I appreciate that. Everyone who works here appreciates that. I'm going to ask you, please, I do not know what the verdict is. I have no idea. I ask, no matter what the verdict is, I ask that you please do not react to it in any way. It's unnecessary. I don't want there to be any issues. If you don't think you're going to be able to contain yourselves, you probably should leave now. Okay? Thank you.
All rise for the jury.
You may be seated. It is my understanding that you have reached a verdict in this matter. Is that true?
Yes.
Members of the jury, please indicate your presence by saying here as I call your juror number. Juror number 1.
Here.
Juror number 2.
Here.
Juror number 3.
Here.
Juror number 6.
Here.
Juror number 7.
Here.
Juror number 8.
Here.
Juror number 9.
Here.
Juror number 10.
Here.
Juror number 11.
Here.
Juror number 12.
Here.
Juror number 13.
Here.
Juror number 14.
Here.
Will the foreperson please rise? Members of the jury, if you've agreed upon a verdict, let the foreperson speak and tell us your verdict.
Okay, the first one we're going to do is Roy Larry. How do you find in the matter people of the state of Michigan versus Roy Dante Larry on count 1, first degree premeditated murder?
Guilty.
How do you find on count 2 possession of a firearm and the commission of a felony?
Guilty.
How do you find on count 3 conspiracy to commit first degree premeditated murder?
Guilty.
How do you find on count 4 assault with intent to commit murder?
Guilty.
How do you find on count 5 felony firearm?
Guilty.
And as to the people of the state of Michigan versus Michael Despicas, how do you find on count 1 first degree premeditated murder?
Guilty.
Of first degree premeditated murder?
First degree premeditated.
How do you find on count, and that was also the same for Mr. Larry?
Correct.
On count 1, thank you. On count 2 felony firearm?
Guilty.
How do you find on count 3 conspiracy to commit first degree premeditated murder?
Guilty.
How do you find on count 4 assault with intent to commit murder?
Guilty.
And how do you find on count 5 felony firearm?
Guilty.
Will all the members of the jury please rise? Is it your verdict that you find Michael Despicas, as well as Roy Dante Larry, guilty as charged on all 5 counts in their matters? Is that your verdict?
Yes.
Yes.
Would you like the jury poll?
Yes, Your Honor, please.
Juror number 1, was that and is that your verdict?
Yes.
Juror number 2, was that and is that your verdict?
Yes.
Juror number 3, was that and is that your verdict?
Yes.
Juror number 6, was that and is that your verdict?
Yes.
Juror number 7, was that and is that your verdict?
Yes.
Juror number 8, was that and is that your verdict?
Yes.
Juror number 9, was that and is that your verdict?
Yes.
Juror number 10, was that and is that your verdict?
Yes.
Juror number 11, was that and is that your verdict?
Yes.
Juror number 12, was that and is that your verdict?
Yes.
Juror number 13, was that and is that your verdict?
Yes.
Juror number 14, was that and is that your verdict?
Yes.
Anything else for the jury?
On behalf
Juror
of
Mr. Thomas?
Oh, yeah.
Members of the jury, thank you very much for your time and attention this matter. If you go back one last time, I will collect those and you will be discharged as jurors. Thank you very much.
All rise for the jury.
You may be seated. Sentencing will be, if it's acceptable, June 12th. Is June 12th work out?
That's fine.
Mr. Thomas, is June 12th all right with you?
Yes.
Okay, June 12th, 11 o'clock. Make sure they fill out.
Yep.
There were two notes, one that says they reached a verdict and one that asked for still photos from the video around the pawn shop, video of the bike shop, and photos from the hospital, and all the exhibits were sent in to the jury. Anything else for the record?
Judge, what time is sentencing on this?
11 o'clock?
Thank you.
Thank you.
Great. Thank you very much.
Your Honor,
Yes, sir.
is the court going to speak with the jurors?
I'm just going to release them.
Oh, okay.
Thank you.
All rise.
This way,
So the innocent man is there at home. Wow.
Are they good? What?
We're working.